Right, good afternoon, boys. What we're going to look at this afternoon is what are the legal implications of a contract. So, in other words, what requirements must there be in order for a contract to be legal? The first one is that the people who are entering into this contract must be legally allowed to do so. So, we talk about something known as contractual capacity. And the legal age in which one can enter into contracts in South Africa is 18 years. So, you must be 18 years or older to enter into those contracts. The second point is that the person or people entering into contracts need to have a sound mind. So the person entering a contract doesn't suffer from any mental illnesses or possibly have had amnesia and can't remember things. So they need to have a sound mind. The third thing we talk about is the fact that this contract needs to be reasonable. The conditions of that contract must be reasonable and should be executable. So, for example, you can't say, "Oh, I'll pay you R1,000,000 if you give me your SAMI." That's not reasonable. So, it's a null and void contract. It really can't exist. The fourth thing is that it must be legal. Okay, you cannot have a contract to go and do an illegal activity such as killing your neighbor or kidnapping someone. That contract is illegal. So whatever the contract says you need to do needs to be a legal thing that you're allowed to do. The fifth thing is that it must be possible. All right, the activities that form part of a contract must be physically possible to achieve. So you can't say in the contract that you're going to run 100 meters in 5 seconds flat. That is physically impossible to do. So if the contract does not answer to any of these conditions, the contract is said to be null and void. And null and void means that the contract does not exist. So even if just one of these things is missing from the contract, it is a null and void contract. Right, so let's now move on to what we mean by a breach of contract, right? So this is when either party fails to carry out certain responsibilities. This is known as a breach of contract. Now, there are a number of reasons when there is a breach of contract. The first one is as follows. If there are any mistakes in the contract, so the wrong date has been put on it. So let's say you were going to rent a building from the 1st of September 2020, but the contract said 2019, and that date has already come and gone, then there is a mistake. It is a breach of contract, right? If there's a spelling error, so that's why it's always very important to check that your name and surname is spelled correctly, or an ID number that's in a contract is correct. So if there's a mistake, the contract is then said to be in breach of contract. The second thing we talk about is if a party is forced to sign the contract and they don't really agree to the terms and conditions of that contract, it's a breach of contract. The third one is the requirements and responsibilities of the parties in the contract are very unclear and wishy-washy. It's a breach of contract. The next one is if the actual activities are physically impossible to do. So my example of running the 100 meters in 5 seconds. And lastly, if one of the parties lied or withheld information in the contract, then that contract is said to be in breach of contract. The party is in breach of contract. So if when I got married to my husband, I lied about my birth date or how much money I was bringing into the marriage, it would be a breach of contract. So I hope that that has helped. It's very important that you understand the difference between what are the legal implications and then what can change that contract and make it not actually physically possible to do. Have a good day.